Dear friends, this is episode number 15 of the Limitation Act. In the last episode, we were dealing with section 6, 7 and 8 as a particular scheme, and we were dealing with explanation 2 to section 7. Explanation 2 says that for the purpose of this section, the manager of a Hindu undivided family governed by Midakshara law shall be deemed to be capable of giving a discharge without the concurrence of the other members of the family only if he is in management of the joint family property. Then I diverted your attention to the pristine Hindu law, and what is stated in explanation 2 is that a manager or karta of an Hindu undivided family governed by Midakshara law would be capable of giving such valid discharge so as to bind the junior members of the family only if he is in management of the joint family property. That is a condition. Otherwise, the manager or karta of a joint family has got certain powers to deal with the matters in the family, properties, debts, securities, etc. And the action of the manager will bind the junior members unless otherwise challenged. That it is not for the family necessity or like that, it can be challenged, of course. Otherwise, it will bind the junior members. But here the position has been clarified that he can be given and will bind the junior members, and he can give a valid discharge so as to bind the junior members. Section 7 speaks of the disability of several persons and capability of one of them to give a valid discharge in respect of others. So the manager of a joint Hindu family is entitled to give a valid discharge so as to bind the other members who are disabled, who are suffering from any disability. But that applies only when that manager is in possession of, in management of the joint family property. That is a condition. So with that, section 7 is over. Section 8, special exceptions. Nothing in section 6 or in 7 applies to suits to enforce rights of preemption. So this will not apply to 6 and 7 will not apply to a preemption suit. That is out of question. Some immediate steps are to be taken, whether the person is under disability or otherwise it is. The principle is the extended period of under section 6 and 7 does not apply to preemption suit, as the right of preemption should be immediately asserted. Minority or other disability would not excuse laches in assertion of the right. That is a Madras decision 1922 MLJ. So that is an exception. Or shall be deemed to extend. I am reading 8. Nothing in section 6 or 7 applies to suits to enforce rights of preemption, or shall be deemed to extend for more than 3 years from the cessation of disability or the death of the person affected thereby, the period of limitation for any suit or application. What is the meaning of this? 6 says that he will get the same period after cessation of the disability. 7 says about the disability of several persons and a valid discharge can be given by other members. We will concentrate on section 6. Same period he can claim after cessation of disability. So for the purpose of filing a suit, the period of limitation is 12 years. He is a minor or an insane person. after his disability or insanity ceases, he will get the same period of, he must get the same period of 12 years going by section 6. But it is subject to an exception that nothing in section 6 or in 7 applies to suits to enforce preemption or shall be deemed to extend for more than 3 years from the cessation of disability or the death of the person affected thereby, the period of limitation for any suit or application. So whatever is said in section 6 and 7, the maximum ceiling limit for extension is 3 years, is the plain meaning of it. A question arises. A person is a minor or an insane person or an idiot. He is entitled to the benefit of section 6 and he attained majority or his disability ceased. From the date on which the period is to be reckoned, he has got 12 years period, let us take it. And that his insanity or minority he had to undergo only for 3 years. So he will get the balance 9 years. But what is the meaning of section 8? The maximum will be 3 years. So that question came up for consideration. Exactly that point came up for consideration in one decision. That is reported in AER 2008 Kerala 33. KHC also 2007 4 KHC 498. It is reported. Citation is Sheila and another versus Muralidharan. See, some of the dates you may note. A suit was filed for maintenance. The first petitioner attained majority on 22/12/96 and the second petitioner on 18/6/98. The execution petition was filed on 20/11/2002. It was contended by the respondent that it is barred by limitation. So from the date of majority 96 and 98, whether those persons who are under a disability minority would get the normal time or maximum 3 years. And it was held in Sheila's case that if the minor is otherwise entitled to a longer period under the law of limitation than the period of 3 years as provided in section 8, the minor would not be deprived of that benefit. Even without claiming any premium for minority, he is entitled to a period of 12 years to execute it. So let us forget about his minority or other disability. He would have got 12 years which he is entitled to. Because of minority, he is entitled to the benefit of section 6. Normally, he will get the same period after attaining majority, but it is subject to an exception that the maximum period is 3 years. That applies where the balance period is less than 3 years. Maximum he will get 3 years. And in this decision, it is clearly mentioned. I will read. If the minor is otherwise entitled to a larger period under the law of limitation than the period of 3 years as provided in section 8, the minor would not be deprived of that benefit which he would otherwise be entitled to. If it were not so, it could not be said that what is provided in section 6 is a benefit to a person under disability. On the other hand, it would be a disability which is created by section 6. Take for example, a decree is passed on 1/1/1990 in favor of a minor, and on the same date a decree is passed in favor of a person who is not a minor, 1/1/1990. The major decree holder would be entitled to file execution petition on or before 1/1/2002, that is 12 years. Under Article 136 of the Limitation Act, in the given case, if the minor attains majority in 1992 and the interpretation which is placed by the judgment is to be accepted, the minor should file the execution petition in 95. Decrees in 1990, he was a minor, suppose he attains majority in 1992, and going by section 8 he will get 3 years. That means he has to file the execution petition in 1995. Whereas on the same date another decree was passed against a person who is not a minor, who is not having any disability, he would have got time up to 2002, 12 years. So can we deny that benefit to the minor only on the ground that he would have claimed a benefit under section 6? Suppose he is not claiming a benefit under section 6, we cannot impose the benefit on him so as to have a disability, further disability. We cannot create a disability by law. Disability, a remedy is provided, persons under disability, a protection is provided, some benefit is provided. That benefit is in section 6 and 7. What is that benefit? After cessation of the disability, he will get the same period after that date. That is a benefit. So a decree was passed in 1990. He attained majority in 92. He will get 12 years from that date, going by section 6. But section 8 says maximum 3 years. I am putting it to you. He need not claim anything, benefit under section 6. We cannot impose the benefit on him under section 6 so as to curtail his rights under section 6. He would get the normal time which he would have got but for his insanity or idiocy or minority. And if he gets more time under going by section 6, 7 and 8, he is entitled to that excess time. Let us take it that the decree was passed in 1990. He was aged 5 years. He will get 13 years to attain majority. Normally he would get 12 years thereafter to file the execution petition. But he will get only 3 years because 13 years already expired on attaining majority. Then he will get 3 years. Suppose he attained majority on the next year of the passing of the decree, he will get the balance 11 years. He need not be satisfied with the 3 years period under section 8. So that if a minor on attaining majority is entitled to a benefit under section 6 or 7, which is subject to the restriction under section 8, but without that benefit he is entitled to more time, he will be entitled to that more excess time. But by applying section 6, 7 and 8, he will get more time than the normal time which he would have got. And by applying section 6, 7 and 8, he gets really a benefit. Then that can be curtailed by applying section 8 for 3 years. That is after cessation of disability, 3 years is the normal period. That is good. But it cannot be made a disqualification for him. That is what is called held in Sheila's case. In the given case, if the minor attains majority in 1992 and the interpretation which is placed by the judgment is to be accepted, The minor should file the execution petition 95, that is within 3 years of his attaining majority. That would not be a benefit of protection as envisaged in section 6, and it would be a disability. This is not what is meant by section 6 and 8. The period of limitation which is available to a person is not defeated or taken away by operation of 6 and 8. And the Supreme Court decision in Darshan Singh versus Gurudev Singh was referred to. Then also the decision in Moidu Haji versus Kuny Abdullah was also referred to. I will cite those decisions. Moidu Haji versus Kuny Abdullah, that was decided by Justice P.K. Balasubramanian while he was a judge of the Kerala High Court. Citation is 1998 2 KLT 691. 691. It was held that if the property exclusively belonged to a Mohammedan minor and the same had been alienated by a person who was not his legal guardian, the said transaction would be void, and applying Article 65 of the Limitation Act and in the light of Section 6 and 8 of the Act, the suit had to be instituted by the condemned minor within 3 years of his attaining majority or within 12 years of the transaction itself. This is what is held. Larger benefit will be obtained under Section 6 read with Section 8, and it cannot be made a disqualification. Now Darshan Singh and others versus Gurudev Singh, AER 1995 Supreme Court 75. 95 Supreme Court 75. Supreme Court 75, Darshan Singh. I will read a short paragraph, that is why I am searching for this. Supreme Court 75, Darshan Singh versus Gurudev Singh. It is in SCC also, 1994 6 SCC 584. Paragraph 4. In other words, Section 8 is a proviso to Section 6 or 7. A combined effect of Section 6 and 8, read with the third column of the appropriate article, would be that a person under disability may sue after cessation of disability within the same period as would otherwise be allowed from the time specified therefore in the third column of the schedule. But special limitation is an exception as an exception has been provided in Section 8, laying down that extended period after cessation of the disability would not be beyond 3 years from the date of cessation of the disability or the death of the disabled person. Take for instance, if a minor acquires a cause of action to sue for possession of immoral property, but due to being a minor, Section 6 aids him to lay the suit within the same period of 12 years after attaining majority. Suppose he dies, his legal representatives would be entitled to lay the suit within 3 years from the date of his attaining majority, though he may die after the expiry of 3 years, since his right to file the suit is extended only up to 3 years from the date of attaining majority. In other words, cessation of disability or death, whichever occurs earlier. The date of death disabled the person, date of death of disabled person does not provide further extended cause of action, a period beyond 3 years after the disability ceases and the death. Take another instance where a cause of action for possession has arisen when the minor was at the age of 16 years. On his attaining majority, he gets 3 years period, but Article 65 column 3 gives him the right to file the suit within 12 years from the date the defendant acquires prescriptive title. His cessation of disability and expiration of 3 years under Section 8 does not take away his right to file the suit within 12 years under Article 65. In other words, the benefit of Section 6 is available to him. Take a third case where the cause of action had arisen to a minor when he was at the age of 4 years. During his minority, the 12 years prescriptive period expired by a flux of time at his attaining 16 years. But on becoming major, his disability ceases. Therefore, he gets a further period of 3 years from the date of cessation of disability to file the suit for recovery of possession from the defendant who claims adverse possession to the plaintiff. Thus, considered that Section 8 is a special exception to Section 6 and 7, and the period of limitation, though barred under Section 3, remained available to persons under disability specified in Section 6 or 7, and the right to lay the suit or application after disability ceased under Section 6 or 7 is regulated by the limitation prescribed by Section 8. So please read the entire decision. We will come to the other decisions in the next episode. Thank you.